Welcome to Raising the Bar podcast,
sponsored by the Ashmore Law Firm.
We're your hosts and siblings,
Gary Ashmore
and Lori Ashmore Peters.
Subscribe so you don't miss a single episode. All right, here we are, Raising the Bar podcast, sponsored by the Ashmore Law Firm. And with me is Gary Ashmore. We've got Hamid Naraghi, who is our managing family law attorney. And with us is Desaray Muma, who is our family law lead. What do we say we called her?
Lead family law attorney.
Desaray Muma, who is our lead family law attorney. This is Dawn. Dawn is our non-attorney spokesperson.
Right.
That
I
helps
get to
us
ask
out.
the fun questions.
A team member
I
for
get to
our
ask the fun questions.
for our Raising the Bar podcast, just for those of you who are interested in who's sitting to my left. Is that correct?
Yeah, absolutely.
So what we're going to talk about briefly, just for a few minutes, is we just finished a big jury trial up in Denton County that Desaray handled. And Hamid,
And won.
We were extremely successful. So Hamid, go ahead and talk about what that was like.
Yeah, thanks, Gary. Jury trials aren't that common in family law cases. Trials in general don't usually go that far, right, Desiree?
Right. I would say about 95% of cases don't go to trial.
Right.
And when they do, most of them are bench trials, meaning the judge decides the decision. It's very rare to have a jury case.
Yeah, right. So when a case goes to a trial, and this was a 1-week trial, so that must have been
6
exhausting.
days, actually, yeah.
That must have been exhausting.
It was.
For you and the client.
Mm-hmm.
But so I wanted to take this opportunity and kind of talk about what a jury trial is in a family law context, how you get there, and how important it is that the attorney that you select not only has the experience on how to handle a jury trial, but really helps the client through the entire process, beginning, middle, and end. So let's get right into it. Talk to me a little bit more about the difference between a jury trial and what they call a bench trial, which is one judge sitting up there deciding everything, right?
Right. So in a bench trial, a judge is going to decide all the issues. In a jury trial, it's going to be bifurcated. So the jury is going to make some decisions. The judge is going to make the remaining decisions. So in Texas, depending on what type of case it is, the jury makes certain decisions. So in a custody case, they determine who's going to be the primary parent, who's going to have the exclusive right to determine primary residence. They're going to determine the geographic restriction. And those are the two big decisions.
Those are jury decisions.
Jury decisions, okay. But the judge still decides the possession schedule, child support, the rights and duties. So who's going to make medical, educational, those types of decisions.
Right.
Yes, there's still a lot of issues for the judge, but the jury is going to essentially handcuff the judge because they're deciding who's going to be primary, and that's a huge decision. So that's with a custody case or a modification case. In a divorce without children, the jury is going to decide characterization of property, whether it's separate property or community property,
right.
And that also handcuffs the judge. And they're also valuation. They're going to decide the valuation. And then the judge still decides the property division.
Okay. So let's take that into like examples. If we have a house and one of the decisions that has to be made is, if the parties don't agree, is this house community property, which means typically 50-50 to both of them, or separate property of one person where the other person gets nothing. And there is a third option, right, where it could be part community property, part separate. You're saying that characterization could be handed to a jury, taken away from a judge, right? And then the value of it. Now, we decided how that house is going to be split up, but whether it's worth $1 million, $2 million, $3 million, that's also a jury?
The pattern jury charges does spit it out. We had it in there initially. We decided to take that out.
Okay. All right.
But besides house evaluation, like, are there other things that get valued besides a house when you're talking about what goes to the jury?
So in our case, one issue was my client had a lot of gold and silver in a safe, about $1 million. And so in that case, the jury found that half was my client's separate property and half was community. And there was some question about how much was community, how much was separate. So in a way, they decided value.
Okay.
All right, that's interesting. So I think it's important that when clients come to us and they say, "Oh, we want a jury to decide everything," that's not really what happens, and they need to understand that because a judge still does have some authority over property division,
Right.
but the jury, like you had mentioned, ties the judge's hands as to the value, whether it's separate, whether it's community, and how that's determined. So I think that's very important for people to think
Right.
that a 12-person jury isn't deciding everything.
Right. Right.
Okay, how do you decide to do a jury trial versus the judge? Like in this case, what made you go that direction? And follow-up question, how do you pick the jurors?
So that's an important discussion that an attorney needs to have with their client before we set this for final trial, whether we want to have a bench trial or a jury trial. In a contentious case, especially where we've had a lot of temporary orders, we have a sense of whether the judge likes my client or we feel may penalize our client. And in this particular jury trial, we felt it was apparent that through just the many unfavorable decisions we felt we'd have a better chance with the jury.
That's a good
And we
point.
did have a better chance with the jury.
That's a good point. So there was a lot of strategy
Yeah.
in deciding, well, if I'm not liking the way this judge is leaning, I may want to take those decisions away from the judge and give them to a jury, right?
Right.
Okay, yeah, I like that.
And in some cases, we may have several temporary orders hearings in a case and they all go in our favor. And if that's the case, I'm going to tell the client, the choice is still yours, but it may be beneficial for you not to do a jury trial. One downside of a jury trial is the cost.
Is it more expensive?
It's more expensive. It adds at least a day, particularly because of choosing a jury. Picking a jury is going to take at least a half day.
Yeah.
And with a jury, there's more starting and stopping because the jury can't hear certain issues. There may be elderly people on the jury that need to take more breaks. And then again, at the end, the jury needs to deliberate. So it adds to the cost.
And you have to stick around,
We have to stick around.
just like on TV.
Right.
Yeah. One of the things that I like that you do, or at least you advise your clients, because ultimately it's the client's decision, right? On certain things anyway. One of the things that I like that you do is, since you're giving so much decision making to the jury, a judge is appointed to your case, somewhat of a lottery system. A case is assigned to a judge, and that's the judge who's going to decide your case. Like you said, that judge may be favorable to your client or may not be. But with a jury, you have some say in selecting the actual jury members, right? You can dismiss them. And I like the fact that you recommend bringing in an expert in helping decide which juries to dismiss and which juries to keep. So you have a better pool of decision makers. Is that right?
That's right.
Yeah.
Yeah. So what happens is we're going to get a panel of jurors, typically 45 to 50 members of the community, and they're going to come in with certain pieces of information on a list: their age, where they live, their occupations, if they're married, single, have kids, what their spouse do for a living. And from there, we're going to get a lot of good information about whether they might be favorable. And then we do a process called voir dire, where we get to ask each juror questions, questions relevant to our case, to get their take on things. And what we're doing is we're trying to find people who could be biased and eliminate them from the jury panel.
So when we all get those wonderful postcards that says we're being summoned for jury, we're being thrown into that pool, right?
Right.
And then you might get called for a family law matter, and then that's the selection process that you're saying you get involved in.
Right.
Oh God, I got lucky that I got out of a jury duty just recently.
Right.
So
we had made a collective decision along with the client to hire a jury consultant in this instance. So talk a little bit about the jury consultant and your experience with that person and kind of what they brought to the table.
So our jury consultant, we'll call him Dr. Steve. He's a PhD, and this is all he does. And he told a story about Dr. Phil. What Dr. Phil started his career doing is what he does. He picks juries.
Oh, okay.
And
that's how you met Oprah.
Yeah, I didn't know that.
Yeah. The cow. There was a cow case involving Oprah.
Oh, right.
And Dr. Phil was the jury consultant on that case.
Oh, wow.
Okay, all right. So go ahead. So
working with Dr. Steve was really incredible. And he was instrumental in picking the jury, and he's watching them like a hawk when I'm asking them questions.
Uh-huh.
And I think it's the combination. One, when I'm asking the questions in the voir dire process, I'm not able to pick up on everything that's going on because there's a lot of information to absorb. There's 50 people there, and I might be asking a question to one potential juror, but we're watching the other 49.
Right.
And so he's watching for facial cues and picking up subtleties in their answers. So it can really get some insight to each juror. And it's essential to pick the correct jury. Just having too many bad eggs on the jury is going to give you a totally different result. And it was amazing working with him.
Right. Okay. All right. Good. So, well, go ahead.
No, I was going to say one of the other things that I like about how you handle your case evaluation from the beginning, and then the progress that a case goes through from the beginning of the case where we start it, and then the middle of the case where negotiations happen and see if we can settle the case or not. And then when it looks like it's headed for trial, I love the fact that you educate your clients on where we're headed. Because like you said, jury trials and trials themselves are expensive, right? To be done right, they're expensive. And you do a lot of cost benefit analysis with your clients to determine, is this going to be worthwhile? If we're spending this much money to fight over this much, it's not worth it monetarily, emotionally, psychologically, therapy afterwards, all of that, right? So I love the fact that you do that. Can you talk a little bit about the progression and how your clients have reacted to that?
Well, hang on. Before you do, how did they come to you? How did you end up getting this client? First of all, you're talking about cost and strategy and stuff like that, but how did they come to you and pick you?
For this client, it was a word of mouth referral. And that's how we get most of our clients, word of mouth referrals.
Right. And these are typically clients who have already had lawyers.
Yeah.
And I was going to let you talk to that a little bit because they've already spent tens of thousands of dollars with other attorneys and they're not getting results.
Correct.
So when that client came to us, I guess talk through what his, I guess whoever spoke with him first, what was that like?
One of the things that we've kind of evolved into this firm where, like you said, people have had other attorneys, sometimes 1, 2, or 3 different attorneys, and then they end up hiring us because the attorneys either haven't prepared the case properly, they have poor communications with their clients, or they've underestimated the fact that this case may actually not settle and go to trial. So they don't prepare ahead of time. They rest on the statistic that most cases don't go to trial. We settle them. And then they find themselves in oh my God, I'm not ready. And they panic. The client notices at some point and they start looking for other lawyers. And we get a lot of those recommendations. Jokingly, I describe it as we're the screwdriver lawyers. We unscrew what other lawyers screw up. So hopefully that's not offensive to all the lawyers out there who screw up. But yeah, we do get a lot of referrals like that. And some of those referrals come from different professionals because the professionals are involved, whether it's the evaluators or whether it's the forensic accountants. And they can tell when a case is not being handled properly, and they seem to refer them to us. Me being the managing family law attorney, I steer them right to Desaray. Because I don't want to make you blush on camera, but you are that good in evaluating a case. Settling a case if it can be settled, and they are mostly settled. But if it's part of that minority that heads to trial, boy, you know how to handle it.
Right. So this particular client, I guess, we all met with him collectively.
Correct.
Because as we explained to most of our potential clients that we're talking to, we take a team approach. And it really is assigning the right attorney with the client based on what their needs are. And so I think that was important. And then I guess after subsequent conversations with him, he chose to hire us. That's
right.
Basically what had happened? Correct.
That's right. And from that point on, you guys had a lot of communications. It wasn't just see me at court. This is our court date, see me there. I mean, you walked him all the way through the process. There was some hand-holding, some educating, because again, not only are their lives on stake, our emotional lives, or their financial lives, the lives of the future of their children. So it's really important that they get educated through the entire process. And you did a lot of that, right? So you guys were speaking how often? Almost weekly?
Almost every day.
Almost every day, yeah.
And leading up to the trial, we did a lot of practice. So one thing that Dr. Steve helped us with is practicing his direct examination and practice cross-examination that opposing counsel would be laying on him.
Why is that important?
Practicing is really important. One, it takes the nerves out of it.
Okay.
And we've seen in previous hearings, when I first got on the case, that my client's testimony was not that strong. And Dr. Steve, with his PhD background, was really able to help him kind of craft his answers. And our client knocked it out of the park under cross-examination. I mean, and I think opposing counsel was a little shocked about how well
Who initially
he did.
wasn't that good, though.
Yeah,
Your preparation, right?
Right. So it was like day and night. And I think opposing counsel was a little taken aback by that, which I got something out of.
Absolutely.
So the other thing is you're this cute little woman and you're going into this jury trial. Do you feel like you're underestimated at all? Because they're like, oh, little lady or something like that. How did you feel going into the jury trial personally? And then how do you feel like the opposing counsel treated you or thought about you? Do you think about that at all?
So in this case, I think opposing counsel knew, I think he recognized my strengths, because we've had so many hearings leading up to this. And particularly we work as a team. And I think he felt particularly behind on deadlines and paperwork. I feel like he probably felt inundated by our firm coming together as a force against him. Kind of threw him back on his heels, but that's just my speculation. And I don't think that in this case anyone underestimated me, but that is a common thing I have seen across my career, because I am very cordial with opposing counsels, and honestly the strongest opposing counsels that I've had cases with, they're the most cordial. They don't have to be nasty because I had the skill set in the courtroom to deal with everything. And so that's always been my goal, is to be cordial outside the courtroom when I don't have to be nasty, but I'm going to stick it to you inside the courtroom. And I don't have to be nasty outside.
Mm-hmm. Right.
That is something I've noticed about you. First of all, I would never want to play poker against you. You're very hard to read, and that's why I would never want to go against you in court either, is because you're right. There are the attorneys who flail their arms and showboat for their clients, and they're putting on a show, but you are very respectful. And that's why I mentioned earlier, when a case can be settled, you settle it. You're not someone who fights for the sake of fighting or impressing your client. If a case can be settled, you settle it. But if it needs to be fought, you fight it aggressively, politely, respectfully, but effectively. And that's what I love about you.
Mm-hmm.
So when you did the jury trial, how did you prep your client for, hey, it could go this way, or maybe it can go this way? Like, how do you set the expectation? Because, how do you even know what it's going to be?
So we had several conversations, and we actually had hired a civil appellate attorney on standby to advise us about different issues.
What does that mean? I don't know what that means. Civil appellate?
If we lose at the trial level, we have the option to appeal.
Okay.
And so we had hired an attorney to be on retainer to advise us and to be ready to jump in the second if we ever lost.
Okay.
And so that was really helpful. For example, opposing counsel filed a motion for enforcement on a spousal support issue. And we weren't sure when he was going to set that. And actually, he kind of fell asleep and never got around to setting it. But if he had set it, he could ask for jail time. And that's going to be a huge problem if my client's in jail and we're trying a jury trial. So we had that appellate attorney on standby to, if necessary, file a mandamus to get him out of jail and beat that case on appeal.
And the evolution of that is important, because Gary mentioned earlier there's a team approach at our firm, which means the client gets the benefit of all the different attorneys at the firm, all the different attorneys' background, their areas of expertise, their skill, and their different perspective on a particular case. I remember having that particular meeting where we discussed, well, like you mentioned, that we had a judge who could be less than favorable to our position or to our client's position. So we anticipated that there may be certain issues that are handled by a judge but handled improperly. And do we want to bring in another member to our team, in this case, the appellate attorney, to help? Because this case warranted it. Remember, just the coins in the safe deposit box were $1 million, okay? So it was warranted in this particular case that what if the judge does something wrong? Do we just duck and walk out? Or were we prepared for even that contingency, where even if the judge gets something wrong, we're still prepared. Our client's not going to suffer the result of that.
Mm-hmm.
So the team was not just us, it's other members outside too.
So as your case is wrapping up and it went to the jury, like, how do you keep your client's nerves under control? Like, are you nervous while you're waiting, or you're like, I've done my job? Like, what was that like?
I felt really happy with my performance. So I wasn't nervous while we were waiting for the jury to deliberate. But once we sat down and the judge started reading off the jury charge and their rulings, their determinations, my heart was pounding out of my chest.
Yeah.
When we got to the first question, which was date of marriage. So there was a question in this case about when the parties were married, because they had a ceremony in Mexico and they were trying to claim that they were common law married, which is like an informal marriage. Then they had a ceremonial marriage with a marriage license later. So we're trying to prove that they got married at that later date. And once they said that it was that later date, which is what we wanted, I knew everything would fall into place. And she kept reading and reading, and almost everything landed not in our client's favor. So I felt over the moon for that.
That's awesome. So after it's all over and the client, what did the client say to you at the end, or what was their reaction?
He was so happy. He was really relieved.
Yeah. So how long had it been going on? Can you say how long?
So
had
it was
that
a
been?
21-month marriage, but the divorce process had been going on for 24 months, 2 years. And this was our 5th trial setting. And it was a bit of a trial by ambush, because opposing counsel filed things 30 days before trial. We were able to get some of those things struck. They didn't respond to discovery. We tried to get that struck. The judge ruled against us, and we still won. So it felt really good.
So after you win a big jury trial, like, what do you do?
Go to Disneyland.
Did you celebrate? No. But 6 days, you're exhausted. Like, did you sleep? Did you take yourself out? You're just like, what did you do? Did you celebrate?
A little bit of celebrating. I still need to do some more celebrating. I took myself out for dinner, a nice dinner, and one of the associates here got me a bottle of champagne to congratulate me. So I've still got that sitting in my office. So I'll need to wait for a special occasion. Maybe the win for my next jury trial, I'll drink that.
Oh.
Yeah, because they are rare. But like I said, she's got one over already, and she's got 2 more coming up. Not to make you panic or think about those already. But yeah, you are well experienced in not only settlement of cases, but jury trials and bench trials. So I love the fact that, again, you have the perspective for all of it, handling a case from beginning to end, not like many other attorneys and I have met a lot of attorneys where, because so many cases settle up until mediation, they rest on their laurels. They statistically think it won't go there. They don't prepare a case from the beginning, which is when you really have to prepare it. And then when it looks like they are headed for trial, they panic themselves and they start bullying their clients into, well, we got to settle this case. You don't want to go. And it's really self-preservation as opposed to the client's best interest. So, I mean, just the fact that you're going to be handling, 3 jury trials in a period of 2 months, it speaks to your level of experience on something like this. The other thing that I want to mention is, I also don't want people to think that every case needs to go to a trial. Every case needs to go to a jury trial. We handle high asset, high conflict cases here a lot of times. And there was a basic skill and science in helping the client decide, put your emotions aside. I know a lot of fights are over principle, but principle is expensive. So helping the client move forward over the process, distinguishing between their emotional issues and then the legal issues, and then you helping them decide, should we settle or should we go forward? That's a big part of your representation, right?
It is.
How do you help them sort through the emotional things from the legal things? Because sometimes when people are in that situation, they're blinded and they can't really filter out, wait, is this an emotional thing or a legal thing? How do you help them to do that?
So it depends on what the issue is. If it's a property issue, then we need to decide, are we doing a cost-benefit analysis, or is this about the principle of the matter? If it's a cost-benefit analysis, I can estimate what it's going to cost to have a hearing, to go to trial, etc. And then we need to look at the value of that asset and see if there's a middle ground. For some people, it's about the principle of the matter. And it doesn't matter what it costs. They know in their heart what's right, and I'm happy to fight for that. When it comes to children, it's tricky. On one hand, you don't want to burn a co-parenting bridge because it's very hard to get back. And even when your children are 18, you still have to see each other. You still have to have interactions, and it affects your children for a lifetime. So that's one thing we need to take into consideration. And on the other hand of that is best interest. And for some people, it's even safety. Sometimes it's a safety issue, and we cannot compromise on that whatsoever.
That's a good point. That's a very good point.
So I know we talk about this team approach, but we don't charge, each lawyer's not charging for their time on the same matter. I mean, on the same
work, on the same
on
task.
same work,
yeah,
on the same task.
That's
right.
exactly right. Yeah, with the team approach, again, the client is getting the benefit of all the attorneys here, all their knowledge, experience, background, perspective, but you only pay for one attorney at a time. So you get the benefit of the whole, but you only pay for one.
Which I think is important because a lot of bigger firms, you're charged for everybody that touches that file, whether it's at the same time during a conference meeting that they're having or whether they're doing things individually. And I think it's important that we pick and choose, what we're going to bill, and it's never a surprise to the client. When they get their bill, they know what they're being billed for.
That's right.
And they know who's going to be billing for it. And if they have any questions, they need to talk about it on a regular basis. So
And they talk to me.
And they talk to you.
That's my
right.
responsibility as a managing family law attorney.
Correct.
I spend as much time. And by the way, there's never already charged for that. We just had a client come to us from another attorney's office where not only were they charged for everybody who touched the case, thought about the case, dreamt about the case, but when she had called to ask questions about her bill, they charge her for that.
Right.
So yeah, that does not happen at our office.
Correct. Okay.
Now, thank you. Thank you for everything you do for our clients. Thank you for this great victory for our client. And I do want to, we spoke about bench trials, jury trials, and the distinction between what a judge decides and what a jury decides. What I'd like to talk about next time is private judges, because that is another option that is no longer reserved for the rich, famous, the celebrities, is they have an option of hiring their own private judge. So let's talk about that next time.
And so many people don't have any idea about it. I even have colleagues in the family law arena hadn't even heard about it.
I remember that.
But yet it's in the code section
Yeah.
that it's a viable option for clients if they want to keep their matter private. And I think that's very helpful to talk about that next time.
It's funny you say that because actually we had one particular situation where we wanted to use a private judge for a matter. And the presiding judge, because they have to sign off on it.
Correct.
They were not familiar with the ability to do that, the legal foundation for being able to do that. And we had to present them with the research respectfully and say, yes, this is why we can. And about 5 months later, they called us and said, could you give us that research again?
Right.
So yeah, that happens.
Right.
I'm sure they were happy to get the case off their docket.
Well, yeah, but we
true.
also did it respectfully the way you do things.
Right.
So,
I know that it's superficial, but I kind of don't feel like it's superficial. Like the way that you dress for court. Do you dress intentionally? Like you can't wear the same thing every day, right? Okay, so like when you're getting ready, it's like, how do you get ready? Like, what's your process?
Well, I start by picking a suit, and that kind of determines the color scheme.
Okay.
And I actually I have an Instagram post of each suit I wore in each of the 6 days of my jury trial.
Okay.
And I got
Nice.
so many compliments. And the bailiff even said he liked my style.
oh,
So
That's cool. That's important. So you had a specific outfit you wanted to do your opening
yep.
in, and you had a specific outfit you wanted to do your closing in.
Yeah.
Okay. And is that all the way down from the way you wear your hair all the way down to your shoes?
It is.
Ah, okay. And you
Okay,
wanted to
tell me about
comment?
the shoes. I love the shoes. I always love your shoes because they're super cute. Like sometimes you wear like the pointy toe shoes, and sometimes like you have a peep toe shoe. Like, does it depend on the outfit or like what you're doing that day? This is the important stuff, by the way.
I'll limit it on what I'm doing that day. So today, let's see, we've got these shoes going on. And these puppies are from Amazon. It was actually a pretty good deal.
I like them because they're feminine, but they're still powerful. Like they have the little bow on them, but it's like pointy tip and a heel. Like it's almost like Cinderella heel on it, right? So I like that. Like girls
So
can
that's important.
appreciate that.
Yeah, no, I'm in a shirt and a tie every day, and Hamid's in all black every day. So it's simple for us, right? It's easy. It's easy. Okay.
Do you ever get so like anxious or nervous or even in the moment where you feel like you're going to be over emotional and not be able to do the thing in court? Or do you just like flip a switch and you're like court mode?
Most of the time I flip a switch, I'm in court mode. I sometimes outside of court, when I'm preparing for court, I feel some anxiety, especially when it comes to cases with children where I feel like their safety is on the line and their life is in my hand. Sometimes I feel some anxiety about that.
Yeah.
Well, her office and my office share a wall. So I get to hear sometimes when opposing attorneys, other opposing attorneys kind of push her buttons. And I see her go up. I see her voice, I hear her voice go up. But then I love that her office has a little bit of a Zen feel to it. And she's got her little water fountain and a little calmness to it. And you can even hear her come back down to center. So yeah, there are moments. She is human. She's a great attorney, but she is human. There are times that she spikes, but she brings it back down the middle.
I think any attorney who doesn't get anxious or even stressed at some point, especially practicing family law, I think is problematic. And to me, that would be a red flag if I was going into an attorney's office and they were either flippant or they didn't get nervous or they didn't care enough about the case, especially when there's kids involved, like Desaray had mentioned. I think that's problematic because we're human as well, and we're fighting for, the best interest of these kids, and it's a life decision. So it is very important, and that's again why I feel like, to hear that we do get stressed and we do, go through anxiety, but we're able to flip a switch to perform, especially in the courtroom. I think it's important.
Well, otherwise you have a robot for an attorney.
That's correct.
And they are out there. I mean, we are human. We do care for our clients, but part of the responsibility we're taking is for us to remain calm when things get out of hand. Right. Part of our responsibility is to bring the case back down to logical decisions as opposed to emotional decisions. So it does happen. But again, part of the professionalism is not to be a robot, but also not to be so emotional that we add to the fire.
So give your key phrase give your key phrase that you tell all potential clients.
Which
that we
one?
talk about.
The
Your
philosophy for family law.
Well, I'm the little Buddhist Zen over here. So yeah, I have a lot of key phrases, but one of them is peaceful settlement, if possible, aggressive litigation if necessary. That's really the motto of our office, and it captures the essence of who we are. Not every case has to be fought. Not every case can be settled. Some cases where you have to, especially when we're not the first attorneys on the case, and perhaps the other side has gotten used to a status quo where they could push the other attorney around. Sometimes we have to kind of show our fangs and say that, look, we can fight, but we choose not to. Can we come back to the negotiation table now that we've shown you we can fight? So,
I didn't know you could switch attorneys, actually.
Oh,
I thought
absolutely.
once
Yeah,
you
that is
picked
a
an
good point.
attorney, like, okay, well, dang, I guess I'm stuck with this person because they're on my case. So for somebody that might be going through the divorce process, Desaray, what would you say to them? Like, is it okay to get a second opinion or to switch attorneys, or like, what would you say?
I think it's absolutely important to get a second opinion if you're doubting yourself. And you can choose to stay with the first attorney or move on.
Yeah. I think the other catchphrase that's important is we don't sugarcoat things here. I mean, we have the knowledge, we have the experience, we have the background. We need to get to know our clients and our clients' circumstances, their priorities, their goals, their challenges. The more we get to know about them, the better. Based on that, we can help develop a plan for their case, for their life. And when I say a team member, by the way, the client's a part of that team. We don't just close them out and say, you retained us, get out of the way, let us handle your case. They're part of this team. And when we find out about that, we also recognize that a lot of the advice that I give is simple, but it's not easy. It's kind of a pet peeve of mine when I give advice and people say, yeah, but it's not that easy. I know it's not. There's nothing about divorce that's easy. Let's establish that.
Correct.
But it's part of our responsibility to handle it logically for people. So I always tell our clients, here's a catchphrase I think that you're referring to, is from the moment you hire us, your job is to not worry unless we tell you there's something to worry about. You need to communicate with us. You need to let us know what's running through your mind, that voice in your head, usually at 2 o'clock in the morning when you're trying to sleep. Contact us and say, look, I'm worried about this. And we'll be honest with you. If there's something to worry about, which is usually only about 10% of the time, we'll have a plan on how to deal with it. The other 90% of the time, we're going to tell you there's nothing to worry about. Go back to sleep.
And that's very important.
Yeah.
Right. Because a lot of lawyers I know don't communicate that with their clients.
Well, I actually used to serve on the state bar's ethics committee and the fee arbitration committee. And one of the biggest complaints was attorneys were not communicating with their clients. So that's something we make it a big point. Our clients always know what's going on. They always see copies of everything that's being prepared on their case, everything that's come in. They know what we're doing, why we're doing it, how we're doing it, and what other options are there. So we never get any complaints about no communication from us.
Right. That's true.
Okay, well, I want to congratulate all of you guys for a job well done, especially Desaray, the whole team. So, good job.
Thanks to our sponsor, the Ashmore Law Firm.
We specialize in probate, estate planning, family law, guardianship, personal injury, and civil litigation.
You can find us at ashmorelaw.com.
Or by calling us at 214-559-7202.
Again, that's ashmorelaw.com.
Or calling 214-559-7202.